firewalls. By defining guardrails and policies on data and usage classifications, we can enable peace of mind by using AI on our data and ensuring full automation and traceability. Let's dive into the features. Need to streamline your legal research? Key Legal summarizes lengthy case laws from trusted sources such as private collections, artifacts, or law databases into concise points. With our extensive connectors, we can leverage multiple data sources to improve your research requirements. Built-in tool automates the process, saving you time, money, and ensuring you get accurate, relevant information quickly. How about document reviews? Key Legal provides answers to documents such as summations, analysis, comparatives, or even redline services, all tools to reduce data. With contract analysis and drafting, Legal identifies key clauses, suggests integrations, and ensures legal compliance, minimizing errors and saving you precious time. Need to generate legal documents like wills or leases? Key Legal has got you covered with its documents and automation to trusted legal templates. There's good and receive documents to will streamline time-consuming processes. Transcription videos. And we can translate it into multiple languages supporting one human language.
It's fine. We can go left there. As soon as that is done.
Now let's address the elephant in the room. Trust, ethics, and responsibility. Security Legal isn't just another AI tool. It's built to meet the highest levels of standards, including ISO 42001, PII, IPA, and OS risks. The key provides capabilities to secure data access, file, and source usage classifications, and enable guardrails and public AI providers to enable secure content and data use. Trust, meaning inputs and storage your data with utmost care and precision. So if you're ready to restore your faith in AI and advance your practice, it's time to get completely legal insurance. Join the future of law with Key Legal. AI, trust. Carefully trust and request Advocacy help from legal to revolutionize your practice.
Good afternoon. You guys the floor. I'm sure you'll find us.
I will guide you on that. Questions and stuff.
Testing.
Almost the exact same.
Good afternoon, colleagues. I think it's time for us to start now. My name is Mos Mpaha SC. I'm the chairperson of the Tshwane Society of Advocates, and I'm here to welcome all of you, starting with our Judge President Mlahevi. Thanks for responding to our request to come and be our guest speaker. And I see we have DJP Lidwaba, and thanks so much DJP for coming during recess. And we have our friend Ms. Kuferki, and you always here supporting us with the DJP. Welcome to TSA. And I see my senior colleagues, Malens SC there at the back, and Etienne Coutier SC. And thanks for our advocates who are here, the attorneys that we have also invited. I see members from the Johannesburg Bar who are here with us. And thank you so much. I hope that this whole issue of AI, we are always intimidated by it, but I hear some people are using it to write heads of argument, DJP. So today we are going to learn as judges how are we going to be able to assess and make sure that these heads of argument are not those of an advocate but of AI. So thank you so much. And Mil Hamil, all the way from Ethiopia originally, she's here with us. And I know you've been so much in the media space, and she's going to facilitate the whole program for us. And I think our speakers will be duly introduced by her. Thank you so much, and I hope all of us can sit back, enjoy, participate, ask questions, and let's not forget also LexisNexis. our sponsor, and thanks so much for coming and supporting this initiative. Avil, please go ahead.
Thank you so much. Can everybody hear me okay? Okay. Welcome our guests, those of you in person, those of you joining us online, and our esteemed panelists. I am indeed from Ethiopia, but I have been here for about 13 years now, so not quite from Ethiopia anymore, but from Johannesburg, so don't hold that against me. But thank you for being here. My name is Amal Balaimer, and I'm going to be your facilitator for our panel discussion this afternoon, the timeless craft of advocacy in a tech-driven world. And I just want to quickly say thank you to the Tshwane Society of Advocates for actually putting this event together as a home to a dynamic and growing group of legal professionals who are not only committed to excellence and innovation, but keeping us at the forefront of these conversations as the landscape is evolving and the duties are becoming a bit more demanding. I think this is a well-welcomed conversation. So thank you, TSA, and let's give them a round of applause. Okay, so a couple of housekeeping rules, just so everybody knows where everything is. We've got emergency exits with doors labeled stairs, so if you walk out this door and go straight down the corridor, you will see them. We will hopefully not have need to use them, but just pointing it out. Restrooms, if you go out this door, it'll also be to the end of the corridor on your right. Kindly switch off your cell phones and, well, don't switch them off, put them on silent so we don't have any disruptions. Once we are through our conversation with the panelists, we will hopefully have enough time for questions from the audience on the floor. So please, hold your questions until the end. And I understand there will be refreshments and snacks right after the conversation as well. So you'll find that if you go out through this door, it'll be on the left side. Okay, so I think we can get started. So today we're going to be diving into a fascinating and equally contentious topic, which is the application of artificial intelligence, AI in the South African legal profession. And our everyday experiences tell us that AI it's not a distant concept, it's not abstract, and it's very much here, it's happening to us right now, and it's actively reshaping how legal practitioners are navigating their vocation as well and how they're operating. And it brings with it challenges and opportunities. Now, imagine a world where we're talking about how AI can help you sift through mountains of legal documents in seconds, or where we're looking at predictive analytics that can actually forecast case outcomes, and virtual assistants who can very quickly mainstream simple administrative tasks, but simultaneously, right? It sounds like science fiction, but it's actually happening. And it's a question of how well we embrace it. And while we're trying to embrace it, we need to ask ourselves questions of how do we ensure that this timeless craft of advocacy remains intact, right? How do we balance the innovation that's happening with the core values and ethical obligations that define this profession? Now, while I will be moderating this conversation, and I am talking a lot about the law profession, I need to admit that I am not a member of the law community. I am actually a communications professional. My questions would not survive for 2 minutes in court, so again, don't hold that against me. But as a communications professional, I also do grapple with some of these issues. So it's an issue that is being dealt with across the board for all professionals in the modern world, right? For today, just think of me as your friendly neighborhood moderator, and I'm just here to keep things engaged and lively, okay? So we're fortunate to have a very distinguished panel with us today, and each member brings a very unique perspective to this conversation that we're about to delve into. So let me start by introducing them. We've already heard their names, so I'm just going to give you a little bit of background for those of you who don't know them. So, Judge Edwin Molaflehi, who's a former judge of the Gauteng Division of the High Court in Johannesburg, and also serves as a judge president of the Labor Court and the Labor Appeal Court. We're very honored to have you here with us, sir. Advocate David Tshwane, who's sitting on the ground with our audience. There he is. So David has 12 years of experience, specializing in a wide array of 16? You look so young, guys. I would have never guessed. Thank you for that correction. 16 years, I apologize, of specializing in a wide array of large fields, including constitutional, environmental, medical, immigration, and so many more. I can go on. And then we've got Advocacy Josana right there as well. So she has 7 years of legal experience, correct? And also an impressive array of fields. She's driven by her passion for knowledge, and she has a desire to effect impactful change. We also have representatives of 2 companies who are at the forefront of AI solutions in the country. So Roy Serra. Roy is Executive Director of Green for Digital, which is an innovative entrepreneurial AI development company focusing on AI applications to a broad spectrum of legal areas, including governance, data and workflow management automation, and robotic automation. And to my left, we have Claude de Villiers. Claude is a legal and commercial professional with a decade of experience spanning the legal, banking, and technology sectors. And he's currently serving as head of solutions at LexisNexis. Both Roy and Claude have extensive experience working in different geographical as well as cultural settings. So we're very fortunate to have them with us as well this afternoon. So our discussion is going to cover a range of themes. I'd like us to get started, so I won't dwell too much on them. I will say that the purpose of this panel is to have, to spark thought-provoking dialogue and get your thoughts engaged. Hopefully ones that will also continue outside of this panel. So let's begin by hearing from each of our panelists. I think maybe what we can do is start with opening statements, very brief ones, and we'll keep it broad enough so we can lean into your vision as the experts that you are. But if you can share with us very briefly how you foresee AI transforming the legal profession. And Judge, I'd like to begin with you.
Thank you very much. Should I use this one? Oh, okay. Good afternoon, everybody, and pleasure being with you this afternoon. And let me recognize my colleagues, JP Lidova and others. Well, I think the starting point is that, firstly, as all of you are aware, all the courts are now rolling out Court Online. That's an important aspect relating to AI. It's got all the features that you would wish to see in as far as AI is concerned. It's going to help us in terms of dealing with the roles. It's going to help us in terms of dealing with how you allocate cases, and also how you can search if you are registered on the system. I got a call, in fact, just to give you an example, as I was on my way here, from one of the judges saying, I hear there's a case like this. I was only given a case number, but I understand the decision was made in this case. I'd like to see what the decision is. And all I had to say was, just get this number, and then you can get into the system, and that's where you will find it. And we found the judgment in less than 5 minutes. That's how the system works. But coming down to AI itself in as far as research is concerned, because as I understand, there's a central point we need to discuss. It's a reality that we are facing. Everybody is using AI. And as I looked at the topic and was trying to reflect, I asked myself, what happened in the past? Because for you to move into the future, you need to look into the past. The past, if I found a case, and it's a high court case, I'd look at the case and say, well, this is what this case says. And then the next thing is I would go to NotaUp, your Juta States and LexisNexis, to say, has there been any change in this case? And if there has been a decision either overruling, upholding, or just noting the judgment, I will know that this is the very case that the law applies to. Now, similar concept applies with AI. When you open, you access it, you look for a case, it will tell you, if you're researching in this area, that's where you can find this case. If it gives you the case numbers or the cases, you then have to verify. And I think that's the biggest challenge that we're having. And some of the cases that have been referred to in some of the notes I saw relates to that. You still have the same obligation as an advocate not to mislead the court. In other words, you don't just cite the case and say, yes, I found this case in AI or in this platform, therefore it is authority. Your duty is to make sure as a practitioner that the court is not misled. And I think one of the cases that will be spoken about relates specifically to that. So in as far as research is concerned, your duty, in as far as the court is concerned, it's to make sure that you comply with the ethics as we know them. Not much has changed. You just have an obligation to make sure that you comply in as far as that is concerned. Now, the other level at which AI operates, and I think that's where the challenge for practitioners is going to come, it's with the algorithms that are being used. The profiling that is being taken, and I'll speak from a perspective of labor law. Now we see a lot of companies profiling people, placing them onto the system, and it may appear as if this is innocent, objective, nothing of consequence, it's simply a data, a record. No, it's not. Some companies are going, and I saw there's already apps that can help you in terms of your recruitment. Now, some of them are gonna profile a person, and then I'll use an example. A person is caught somewhere charged with misconduct for theft. He goes to the disciplinary inquiry, he's found not guilty. But the algorithm that's already been developed places the data of that person as a person who has already been charged with theft. So what happens when you apply? AI then says, no, not a good candidate because of this. So it's then for the practitioners to start challenging and questioning those things. I mean, in other countries, like in the States, I see in their sports field, they're now looking at putting gadgets into players. They'll be able to determine if you're a footballer, how long do you run? How many passes have you made? And when they assess your performance, they'll assess it on that basis. Now, that's for you to equip yourself as a practitioner as to how you're going to challenge those unfairness and discrimination in a sense. I mean, profiling is going to lead also to racism. We know in South Africa, we are faced with that bigger challenge. So that's what I wanted to say, but also just to cite to you, I saw a case this morning of Forsyth, now the other name escapes my mind. This case relates to a challenge for a claim for defamation. And the question was whether a company can sue for defamation. And it was in the regional magistrate court from what I saw. And the magistrate found against the plaintiff. And then there was an application for leave to appeal. The lawyer cited 9 cases. Of the 9 cases, only 2 cases were cases that exist. The rest of them were nowhere to be found. Now you can see the challenge that we faced with. The magistrate postponed the case the first time, the second time, the third time, and finally decided, I've got to go and dig out this. Now let's reflect on that in terms of the costs. I don't know what the position of the plaintiff was, what the position of the defendant was, but clearly we've lost time in terms of court. We always complain about backlogs. We've cost implications for both parties, and so that's what is important in terms of preparing for when you use the AI tools. I'm sorry. Thank you.
No, thank you so much. No, that's definitely a good taste of all the various topics that, all the various themes that we will delve in today. But while I've got the legal arm of the panel speaking, maybe I can also ask David and Sebastian to add your thoughts on how you see AI transforming the legal profession.
Thank you. I think from the advocate's perspective, it provides real time, you are up to date with almost everything. Gone are the days when you have to wait for your attorney to bring you documents because you can access documents. Gone are the days when you have to have to carry files and files into court when you can simply have them on platforms such as OneDrive, Google Drive, where you can simply share everything. Even when it comes to drafting, you can do that simultaneously as a team. When you can share a document together, then everyone goes through the document at the same time. So it has somehow, or there are environmental benefits to it, because you save paper, but also it provides that convenience that you don't have to wait for documents over and over again. And it makes your practice much easier. Yeah, I think that's how one can incorporate it.
Thank you. I also echo the sentiment that having artificial intelligence or AI incorporated in your practice certainly improves the efficacy of practice, leaving you with a lot more time to focus on your preparation, which would include, and not limit itself to, verifying the sources of everything that you're doing, because the information has been brought to you in a condensed form that you can now consume at a much better rate. And in my own practice, I also certainly can say it has helped me improve just turnaround time on papers and preparation and getting everything done and still having time to sit down and be a human being outside of practice.
Sorry, I just want to pick up on that and illustrate with an example. Those who practice in labor law would be aware that we had planned to implement the court online some time back. We actually implemented part of it in August. But the biggest chunk of the work we do, 80%, it's reviews. Now, when we try to upload the reviews, we encountered a problem in that Court Online doesn't link with the audio recordings from the CCMA and the Bargaining Council. We sat one afternoon and I was really frustrated with my secretary. And we started playing around. How can you upload? How can you indirectly upload? But the long and short, we got an answer that says, why don't you go into OneDrive? Let CCMA upload onto OneDrive and then direct it to you. You can upload it from OneDrive and then you have that audio record. And once you have the audio record on OneDrive, you transfer it into Court Online. And it takes literally, initially we thought, it's going to need 4 or 5 people to work on this. It takes one person, it takes literally 2 minutes to complete the process of getting the CCMA record onto the Court Online. So I just wanted to emphasize the point of how speedily AI can assist you.
Thank you for that, Judge. I'm hearing efficiency, I'm hearing, saving a lot of time and eliminating, labor that's otherwise usually the crux of these processes. But also, Roy, I'm seeing you nod your head.
Getting excited.
Yeah. What other aspects do you think you can also share with us?
Good evening, everybody. So just also want to declare I'm not a lawyer. So there's 2 in the room, I guess. I am an engineer. So look, I've built software for a living, which is fantastic. So appreciate and all protocols observed. Thank you for the opportunity. So been hearing the conversation, and I'm going to try to bring a different perspective in terms of what's happening in other industries as well that we can have learnings from. And we've been building AI solutions now for quite a few years now. And one needs to understand a couple of dynamics around AI capability. And I think we use the word AI sometimes a little loosely, because AI has actually been around for many, many years. It's actually been around since the 1960s. So walking into the room, there's AI that actually enables us. Really where this has come from the forefront now is 2 years, 3 years ago now, this concept of what we call generative AI has emerged. And that's kind of taken the world by storm now, which is the new sort of inflection point in technology. And as technologies have evolved, new competencies have had to emerge, new tools have emerged. And with AI, that's not going to be any different. The elephant in the room is, and we get asked often, is my job at risk? The reality is, no. What will happen is if you do not adopt AI, then potentially you may lose a customer, and that's what creates a job risk. There was an article actually published this morning. There's some new statistics that just came out, and this world is evolving daily, literally daily. Every new technology, new advancements, And the concept of generative, just generation, just think to that moment, AI generating AI. And this is the evolution of where the technology could potentially and will potentially go. So as one contemplates, will your job be replaced? No, it will not be replaced. But AI can definitely augment, can definitely support the way you work. It can enable you in different ways. The beautiful concept in terms of transcriptions into court records or paper records, into be able to use it to generate different document types. We actually have that working outside, so it's lovely to see that potentially. But that really stemmed from the fact that there's gaps, there's skills shortages, and that is also part of the transformation of adoption of AI. So where's the skill shortage, for example, immediately, is lack of translators. So we got approached some time ago, can we create an AI solution to do exactly that? Being able to transcribe and translate, because not everybody speaks English as a first language. So how do we cater for inclusivity? And that's the power of AI. That's what we are able to easily be able to take tools and build these kind of new capabilities. And with these new capabilities, that will augment the way you work. Now, the practitioners that don't take these advantages of these kind of capabilities, they will naturally lag. They will naturally lag to less competitive and being less competitive, of course. So the statement that was made this morning was there was about a prediction that there will be about 228 million jobs at risk, of which 168 will be retooled and reprovisioned, and about 40 million, give or take, that are brand new roles that we haven't even thought of yet. And as a practitioner in the space, I was just sharing with the judge now, when we're building software, I'm looking for new roles and new skills and new competency every day. And this is the challenge at hand, because it's about taking these kind of capabilities now, embracing them, and really kind of crossing that abyss to learn these new technologies, new tools, inform oneself on how to use them pragmatically, correctly, so that obviously you don't create a situation where you compromise yourself. And I'm sure we'll share a few more examples as we go. But let me maybe allow Claude to say a word.
Thank you, Rui. And thanks everyone. That's to the Tshwane Society of Advocates. It's a wonderful honor being here, especially here in Tshwane where I did my article. So it's good seeing some faces that I recognize from practice. I think the main thing that the judge touched upon that really we all have to bear in mind is ultimately, as legal practitioners, we remain we're the place where the buck stops. We remain the custodians of the knowledge that we present to the court. And I think that's very important to bear in mind with regards to legal research specifically, but with any interaction that you do in your day-to-day, you are ultimately the custodian of the information that you're disseminating. And in that context, we at LexisNexis understand the legal fraternity. We're in the privileged position of not only having operated in the legal space and in the legal research space for upwards of 70 years now, but we're also at the forefront of developing Gen AI technologies for specific use with legal practitioners. Now, obviously, we'll touch upon the Mavunda case a little bit later, but from our side, our main challenge is to pair the capabilities and all of the efficiencies that we've just heard all of the other panelists mention, along with trust in the information that you receive, and along with making sure that that information is usable and friendly and from a source that you can trust. One of my co-panelists on a former panel that we had on AI with the Attorneys Association said very similar to what Rui said now. The question was posed to him, will AI replace lawyers? And the answer was, it will only replace lawyers that don't use it. I think the main takeaway for me from a legal practitioner's perspective, but also as somebody who's working for a company on the forefront of AI technology, is that AI remains a tool, and that's especially true in the legal fraternity. Ultimately, the legal practitioner still has a role. He's still the custodian of the information. He's still the officer of the court, he or she. And we at LexisNexis aim to empower the legal practitioner, not replace the legal practitioner. So it's exciting being on this panel with everyone, and we look forward to chatting with everyone.
Well, okay, thank you so much. I think we have definitely touched on a lot of the themes that I'd like us to delve in for the coming moments. But and by the way, I did forget to mention that at the end of the session, there is also a room set up where you can actually learn more about the solutions that both companies are currently putting out there. So I just forgot to mention that. I'm hearing a lot of points about real time and creating access to law, particularly in cases where that's not always been the case for how slow the system has been. And you do make a very, very compelling point about AI having been around for a while, but now there's also generative. And it speaks to, yes, the fast evolution and how quickly we must also evolve with it because it's changing on the daily. So we're talking a lot about how AI supports the profession, and I don't want us to go back, but I do want us to look at, you just take a realistic look at what is happening out there. And I'll start with the advocates, who can give us their, real court experiences. How do you feel, David and Sebastian, how do you feel that sometimes this tool can undermine what are the traditional skills of an advocate? If you can give us some examples.
I think it starts with, it's got its pros and cons because one, the amount of information that is readily available. Sometimes it becomes a lot to consume at the same time and can be misleading. So it requires one to step back, take time and reflect on the information. Is this the correct information? And the good thing about it is you now have got your JustaStage and your LexisNexis online where you can simply verify the information because it's easy for anyone to put up information on the net or elsewhere, and then when you just start punching in Google, just punch in the keyword, then you get all this information and you might go like, yes, I've got the information that I was looking for, but only to find that it's not what you're looking for. But also at the same time, when you're in court, it's the most effective tool. But I think, I'm happy that Deputy Judge President Dwaba is here because it looks like our court systems, our courts, are not ready for AI. One, the Wi-Fi capabilities in our courts are not up to speed because you get to court, the Wi-Fi connectivity or the network connectivity is not as good as it is. Then, though that disadvantages you, other than your colleague who's using paperwork, because now you have most of your information is stored online, your presentation is stored online, but you can't access it because of the network connectivity. But at the same time, it provides one with quick references, because instead of prowling through a lot of papers to the irritation of the judge, you're easily able to point the judge to the correct papers and the correct passageway you're looking for. So I think what it would require for it to be effective for practitioners would also require a buy-in from the courts to ensure that the systems, they are equipped with proper systems that will enable practitioners to use AI. Like, for example, in a trial system where one has to go through bundles and bundles, if courts are equipped, for example, with TV screens, monitors, where one can simply beam the information on the screen for everyone to see, instead of people having their heads down looking for the documents, that would also assist. But I think it just requires that the court system also adopt. It's not enough for one to say, we've got a court online, but are the courts themselves infrastructure-wise able to adopt AI and to enable practitioners to fully give effect to it? So that's what I can say.
That's fascinating. Sebastian, do you have any other examples of how it can undermine skills?
Insofar as undermining skills, I don't believe so. My experience has been that when a person walks into your chamber and they have all this information before them and they're telling you, the advocate, just how exactly the case is supposed to go based on what they've managed to Google, it actually highlights just how smarter or more efficient I am in giving you the correct information and leading you in the correct direction. One other issue is that you'll find reliance on international jurisprudence, where a person doesn't know how to discern between our cases based on how we cite and perhaps Canada or the United States or even England. That personally, I feel, makes me look better as the advocate, because I can sit there and say to you, thank you for everything you shared with me. However, within our own jurisprudence, this is what we have found. If anything, I think, no, AI, I don't think has its pitfall. I mean, 1 or 2 pitfalls here and there, but nothing serious.
But tell me about those pitfalls.
I mean, like, again, it's an overconsumption of information, as has been shared by David. Again, the readiness to just anyone who can just grab it. Yes, we should all have access to the law, without a doubt. However, that ability to discern between what is and what is not, what is old, what is new, what is different. People perhaps do not have an understanding even of the hierarchy of our courts, and perhaps they will go and rely on a high court judgment, whereas on appeal the Constitutional Court has decided differently, or even developed better principles behind a case. I would say that'll be the only issue, or maybe the smallest pitfall that I would say for a layman, or even perhaps the less discerning practitioner, that they would have, is to say, I have found this, it's the most referenced one, but the recent developments perhaps won't be, or won't have as many hits on a Google search as the next case.
But it sounds like you have one up on AI, so that's great. Okay, so let's take it to the courtroom, and from your perspective, Judge, and looking at your role as a judge and evaluating advocacy skills, how do you see AI sort of impacting that dynamic? I understand from a functionality, there's a lot of tools that you're taking advantage of, but in terms of how the dynamics play out from judge to court to defendants, etc.
Yeah. Well, let me answer advocates' concern. As far as I'm concerned, all the judges, and I've traveled across the country, all the judges are supportive of AI. Well, at least to the extent that case line is concerned. Yes, I serve on the subcommittee that convenes at Jayit. And yes, we've picked up some of the problems, but those problems are not unsurmountable. One of it is the connectivity. Yes, there has been courts where there's problems with connectivity, but Johannesburg and the Labour Court and the other courts, I don't think they have that problem. I think it is receiving attention from the technicians. In the Labour Court, for example, talking about the screens, we have now secured the bigger screen to facilitate the hearing virtual. We can run, we call it a virtual court, which will facilitate access to hearing of cases. We complain about shortage of judges, we complain about shortage of courts. AI has come in to help us there. We no longer have judges having to wait. There may be 1 or 2 judges waiting, but if there is that problem, we fall back onto the virtual court and cases can be run through the virtual connectivity. But let's come back to what I think is the critical issue of AI. For me, the critical issue is the ethical rules that the council are required to comply with the ethical rules. It is your duty to make sure that you double check. And I think it was mentioned by Roy that because this uses a language that gets fed into the system, if you say, check for me condonation, it may bring back something else. It may read condonation as condotion, and it gives you wrong feedback. So if you are not careful with those, it may create problems. But some of the platforms, like, for example, Copilot, when they give you the judgments or whatever the law is, they normally reference those. So it is important to also go into those and check. If it refers to a particular case, double check and see whether this case indeed is there in the system. Okay. But talking about the transcripts, in the Labour Court, I find that's the most frustrating aspect when it comes to litigants. It's the worst delaying process, because firstly, it's got to be uplifted from the CCMA, comes to the registrar writes back to them, come and pick up your record, go and transcribe it, and then the next moment the person says, well, I don't have money. Now, when you look at the systems now, your virtual courts or your Teams recordings, they produce records up to scratch. So I don't know why we should not be pushing to say, let that be adopted so that it can be used. In fact, let me tell you, I'm one person who likes telling stories. We sat with the DJP in one criminal matter, which had been going on for honor. It was an application for admission as an attorney, but this person was sitting in prison and was playing all kinds of ways that we know how litigants do to get things going. And we then resolved that to finalize this, we must actually make sure that we prepare the judgment in advance. We agreed with the judgment, we got into court. Remember the olden days of load shedding? Lights went off. And then the secretary stands up and says, Judge, it will take 5 minutes. We're sitting in darkness for 5 minutes. And then something said to me, but this system should be able to help us. I then said to the DJP, the secretary has got the laptop here. You've got a laptop. We can connect to Wi-Fi. Let's tell the secretary to sit a little bit far away from us. Let's connect into Teams. We connected into Teams, and the DJP read the judgment. Well, of course, we told the parties that's what we were going to do. Read the judgment into the record. And it was agreed that that will constitute the record. And the judgment was recorded fully and properly in that particular system. So those are some of the creative ways that we should look at in terms of how we deal with it. But coming back to the issue of ethics, I see in the South Wales, New Zealand court, they've now passed a directive that deals with some of that should be applied in as far as participating in the AI or using AI in court. One of it, for example, is a rule that says you can't use AI to draft an affidavit. You can't use AI, I think, also to draft your summons or pleadings and things like that. But also, more importantly, it requires that if you use AI, you must upfront disclose to the court that this is actually AI-generated document. And in that way, you'll be helping the court to also immediately look at areas where that needs to be checked.
So if I may add, so there's a couple of important aspects here, and I think a couple of topics that have come out. So from a technologist perspective, it's good to understand in terms of these models, these languages, and how AI sort of works in terms of these concepts of hallucinations, for example, because that's really what was sort of emerging there. And one needs to understand this concept of bias in AI, and we discussed it just now, and it was mentioned by Judge. So understanding this and having a duty of care and oversight in terms of documents that you prepare or use AI to create, there's always has to be this oversight in terms of how the transparency and the bias of the model you use to generate the language or to generate the document. AI is founded in languages, and it's based on very scientific algorithms, mathematical models that can infer and can also infer incorrectly. So a big pitfall is to understand those limitations and constraints. And there is this duty of care that one needs to be aware of so that you use the technology responsibly so that at the end of the day, when you do create that document and that output, it does obviously have merit. So one should always just be careful, never to just take it for granted that it's always accurate. It's not entirely the case. And that is a big pitfall. The second sort of problem statement, and it was mentioned in terms of courts, a lot of this is based on data. So everything that we create is data-driven. Somewhere there is data. And there's also a duty of confidentiality that needs to be taken care of here. So when we're bringing capability down to court level, when we're bringing new technology and using the technology to advance the way you work, one has to take extreme care in terms of how you handle your data. We've heard things like OneDrives, G drives, wonderful tools, and they enable you. But your data is sitting in these spaces where it could be compromised. So apart from the tool set that you use to generate your documents, make you more efficient, there's got to be an oversight in terms of care of the data you're producing. And that is typically something we see often across most of the customers we've served, that's sort of almost a second thought. You save a document somewhere, it's okay. But that document could potentially become a breach in terms of client-attorney privilege. Now you've got a scenario on your hands that's probably not pleasant. So again, bringing these kind of technologies into production does also require additional oversight, additional technologies to secure things like data, making sure that you don't get compromised, and making sure that your, obviously, confidentialities are not compromised. The last point that I wanted to bring out is a concept around what we call private AI. So you'll see trends and patterns in AI at the moment. So let me take a step back. When AI was first emerged and there was big announcements, OpenAI, GPT, wonderful tool sets, everybody jumped on there, the fastest growing platform ever in terms of subscribers. And everybody just dumped all their private information onto that world. Fantastic, right? That is just great for the guys that create the models, because they've got your data to now go create new models. So the concept of private AI is now emerging. This concept of be careful of what you put in the public domain and what you keep in your private domain. And having the safeguards, the guardrails, the firewalls to protect you and breach of that data into a public space. Because whatever you put in the public domain, and I love it, customers do that all the time. They put this, I caught myself doing it, by the way. So we put our public information in a ChatGPT. It's no longer private. It's public.
So when you say your personal, like, what kind of data are you exactly talking about?
Could be anything. It could be anything. Could be your customer records. It could be your birth certificate.
So actual identifiers.
Identifiers, identity documents, agreement types, confidential agreements that get pushed out into GPT world, and suddenly you've created a new document. You forget that document sits out there. And that becomes sort of the areas of concern. So one needs to be very, very mindful, very conscious about this. Now, an analogy that, actually not an analogy, an example that in healthcare that's actually being adopted these days is any of this data that is being used and AI generated has to be authenticated, has to be stamped, has to be approved by somebody that said, we've looked at this and we are taking responsibility and accountability for the data that's been created, the data that we've now generated, and where we are storing that data. Because obviously we're dealing with medical records, private information, we're dealing with patients, of course. So again, maybe taking a learning from that aspect. The fourth aspect, and I love what Judge said, is come new responsibilities, right? So maybe, appreciate it, thank you.
Yeah, Roy, very good points you bring up there. And I think all of us so far, Judge, that the practitioners, yourself, have brought up individual responsibility with regards to AI. The directives issued in New South Wales speak to that. But I think to take a step back, I think Silicon Valley in general and technology companies overall have always been very good with developing technology irresponsibly and then putting the responsibility on individual users. I mean, the congressional hearings into Facebook's conduct in the last presidential election is a very good example of that, where Silicon Valley basically took a step back and said, well, we developed this for the better of everyone. And if people use it to profile, and spread misinformation, that's on them, that's not on us. And now we do feel differently at LexisNexis. Our motto globally is advancing the rule of law. And Judge mentioned all the ways that technology is bringing access to justice to people who ordinarily wouldn't have that access, through Court Online and through, being able to email judgments directly to a client instead of having him going down to the basement, taking a half an hour of his time, finding the right case, making a photocopy, paying for that. All these ways that technology can make the world a better place. And we really do feel that very strongly at LexisNexis. It's why we haven't launched our AI model yet in South Africa. We've already launched it in the UK and Australia, Austria, France, as well as the USA, obviously, which is our key market. But in South Africa, we've sort of delayed it purposefully because of a lot of the pitfalls that Roy has mentioned. Because we do feel as a technology company, we have responsibilities. we train our model only on our own data. So the data that you get from the AI model that we're building will come from our database. As Judge mentioned earlier, you'd go to Notarum and check if the newest case law is available, or what judgments were referenced in the judgment that you're reading at the moment. Now, the advantage that you'll have in our system is that you'll have Gen AI, which is like a ChatGPT, which will formulate, for instance, which will generate case law for you. However, you'll also have immediate access to the references. You'll be able to read the case law yourself. You'll be able to see judgments it was based on. And all of it links to our platform. So we really do take that responsibility very seriously.
These are all very, very interesting points. And by the way, I imagined this conversation unfolding much slower in my head. But our enthusiastic experts have touched on all the themes that we will still go into. But I love the point that you're raising, which really highlights the need to also make sure that we have systems in place where everything can stay updated, so we have that ecosystem. But to David's point as well, the reality is we do have courtrooms that have terrible Wi-Fi. And so while it's great to have judges who are, in full support of having these rolled out, how do we actually get that system together? And I will ask you all later your thoughts on how we can actually get that started. But I do want us to take a step back because I am interested in the details of a lot of what was already said. And maybe I'm just fascinated because I'm not the legal person, but I do want to take us back to the courtroom. And I want to talk about the human element, which, AI is great. It's helping us move faster, seem smarter, connect us to, different contexts. But there is an undeniable human element that, again, defines the profession and goes into, be it defense or decision making. And I want to hear from you, Judge. What do you think is, AI will, I personally don't believe that AI could fully replicate, what makes us human. But how do you feel it impacts, the nuances of decision making? Do you think there are still pitfalls that can sort of separate us from that, or do you think that it actually does sort of enhance that and help us still, we can maintain both. We can be as human as we need to be, but still embrace these technologies without necessarily having a rift. What are your thoughts on that?
Yes. Well, somebody said, in fact, it used to be a common understanding that a good advocate is the one who makes a lot of noise. And the ordinary people on the ground believe that. I'll tell you a story. Some years ago when I was young, we sat in a magistrate court in one of the courts in Limpopo, and we were going to do a labor matter. But before we got into court, there was this advocate arguing strongly in court about the criminal matter. And a client came and said to me, "But can't we get that advocate?" So, but the essence of it, you can't take human element from it. If you take human element from it, for me, that means your products or whatever you may have researched on AI, it's gonna be very poor. What wins you the case is the presentation that you make in terms of your heads of argument. It's not so much what you loudly say. So the human element, if you take it away, we're gonna have all these problems that we're talking about, misleading the court, undermining the court, costing your client a lot of money because you'll go there. And some judges may look at your papers and say, okay, this is where you're going, I'll go and do my own research, and may not even postpone the case and come back and blow you, and only to find that, in fact, a client that had a very good case loses because you have not done your work. So I can't see how you can separate the human element. As I said, historically, you take all those big books, open them up, and then go on the next step, go and find the nota up, check what is the latest, you struggle finding out. For me, AI is no different to that. The only difference is that it's quick and fast. You click on there and it says to you, this is case so-and-so, face so-and-so. Down there, there's note up. You press note up, it gives you the whole long list of the cases. It's then for you, that human element, to say, let me see, this says referred to, acknowledged, approved, or upheld. And where do you go? Of course, you go to upheld. and see whether that's where you want to go. So the human element cuts through across. You can't just cut short corners. And I must say, I play around with this thing a bit whenever I get a little bit tired. I've seen Copilot. If you say, find for me, and I'll use again condonation. You say, find for me cases dealing with condonation. It gives you a whole long list. But you may be dealing with condonation on another issue, for example. You're dealing with failure to explain why you did not file your condonation in time, once you became aware. Now, it may just give you condonation in terms of, yes, provide the explanation, the reasons for the delay. But you have not told it that what I'm looking for is that there's a point raised about the delay in filing this very condonation. So it doesn't give you a full answer. Now, if you don't apply your mind, you're going to copy and paste that. And then the turn of events, the judge says, well, your condonation is thrown out simply because you have not explained. And there may be an explanation why you delayed in filing your condonation, just by way of an example.
Okay. I want us to watch a clip. Some of you may have already seen it. I think it was making the rounds on social media. It must have, because I also found it on my line. But I think a lot of it speaks to, again, some of the issues that we've raised, and I think we can also delve into it a little more. Mpile, can you play the clip for us, please?
Owens has submitted a video for his argument.
AI, don't fail us.
The AI has gone faulty.
We will hear that video now.
May it please the court, I come here today a humble proceeding
All right.
before a panel of 5 distinguished justices.
Is this, hold on. Is that counsel for the case? I'm sorry?
He says, I generated it.
Okay, it would have been nice to know that when you made your application. You did not tell me that, sir. I received the application. And you have appeared before this court and been able to testify verbally. In the past, you have gone to my clerk's office and held verbal conversations with our staff for over 30 minutes. Okay? I don't appreciate being misled. So either you are suffering from an ailment that prevents you from being able to articulate, or you don't. You are not going to use this courtroom as a launch for your business, sir. So if you are able to shut that off. If you want to have oral argument time, you may stand up and give it to me. You have 5 minutes.
We can stop it now? Okay, shame, bless him. It was a little very uncomfortable to watch. I want to ask Roy and Claude, do you think we will get to this point where we have avatars presenting? Is that a likely scenario for South Africa anytime in the near future? And for those of you interested, I'm sure you can find this clip very easily available on the internet. He does go on to verbally present his speech, but he does actually struggle. And it actually does speak to her question earlier, if maybe he does have some kind of inability or disability to speak, which again, one can argue the merits of, is this the way to go? She should have been more supportive and all of that. But, bringing it here, do we have mature systems that you think would allow us to have this be a real scenario in the country?
Thanks. It's a great question. I think your question has 2 facets to it. The first one is it even possible in South Africa with the infrastructure and some of the issues that we've mentioned? And I think the answer would be no. Theoretically speaking, you could program something like that in a court online setting, but I would like to think that our legal system and our legal practitioners are robust enough to be able to repel that sort of thing. And I think the case that we're going to be talking to later, the Mavunda case, proves that. right? Like even though it is possible to sort of fake it until you make it, at some point it will catch you out. So technically, I think it is definitely possible, right? This gentleman showed it, and I mean, we have access to the same technology. But will it happen? I don't think in the near future, and I certainly hope not.
So, slightly different opinion to Claude. So we actually have got it working. But yes, infrastructure is not yet ready. It does require a lot of processing capability, and that was a discussion just prior to this. There's a different trade-off for that in terms of being able to provision these kind of services, because it does require a significant investment in infrastructure to make it work. The concept here really talks to the issue around objectivity, and to bring in an avatar, to have an AI conversational bot. We're already doing that in some other industries. We actually, tomorrow morning, we're actually presenting a solution for the medical industry for one of the hospitals, but not in the context of being a doctor avatar. It will be for more the remedial administrative tasks, which we can then add value. Again, to that concept of being very careful to replace human-centric dynamics and capabilities. For example, AI is very objective. So we need to be very careful on how we generate, because there's no emotion. It's a very, very definitive statement. So when we're using models to generate speech, to generate conversation, it's still it's very unemotional. There's no emotion attached. And when we're talking about abstract concepts, we got to again be very careful of being able to use the right tool for the right purpose. And I always say to everyone I engage is, what is the problem we're trying to solve, and use the right tool for the right purpose. Identify the right use case, and then use the right technology to fill that gap. Is it going to replace practitioners in a courtroom? Not in the short term, I agree. Could it potentially offer different value services in administrative tasks to run your practices better? Absolutely. I was actually quite embarrassed. We probably have all got these tools that come into our teams that do recordings and transcriptions. Judge mentioned Teams does transcriptions, for example. So we all have these Ottos and other Fathoms and other tools. So we were playing around with it, and I managed to I did it. I've got about 12 of them into one meeting. So I was talking to a bunch of avatars and one customer. It was quite intimidating for the customer, so it was quite embarrassing. And again, these are the kind of things that happen. So these are the tools where you could definitely get an advantage of, but being conscious about what tool for the right use case. And again, being pragmatic about the fact that you're dealing with emotions, you're dealing with sentiments, you're dealing with different kinds of human cognitive capabilities that an AI type model cannot understand at the moment. There's advances in deep reasoning. There's a lot of advances in terms of R&D going into technology to kind of get those capabilities going. You would have seen Elon Musk's robots walking down. So eventually that's where it will go, but probably we're good 10 to 15 years longer before we get to that kind of capability. So again, bear in mind that the right tool, right place, right use case, then that kind of capability comes through. To that video, I think that was the other part of it, that the lack of that transparency that was mentioned earlier is what probably got the judge quite upset. Can we use the tool to do things that are maybe less sensitive and with the right disclosures? It comes back to the guidelines and what is the right and wrong thing to do in using the right tools for the right purpose.
Right. I wanted Roy to speak first as well, but are these the same reasons why you're saying that you hope we're not heading in that direction, or are there other considerations that you're also thinking of?
Yeah, definitely, and I agree with Roy. I mean, in a lot of context, that sort of thing will happen. We will have virtual avatars as assistants, as administrators. I mean, I think that technology is already here. I think my reply was more in the context of a courtroom and replacing an actual legal advocate appearing in front of a judge. And as I said, I mean, I think technically it's possible, but you know, I should hope that it doesn't happen anytime soon in this country.
And let me just play devil's advocate. I mean, I understand, again, we don't want, you know, AI to replace humans. We don't want this technology to take that place. But if it does facilitate, again, if it does add to ease, like, for example, that man who I do believe struggles to speak in public, and he probably thought, this is my way to do it, why not?
It's a very fair point. I mean, and without the context of how he was appearing in front of the judge, it's difficult to say, because if he was appearing as a witness and he generally had a stutter, you know, you could argue vociferously that avatar is actually a means for him to achieve justice, because he can't, you know, he's not able to witness for himself. I think the judge was angry because she was saying that he had spoken, but I mean, that's a very valid argument. You know, I think as long as the way that we're adopting this technology is underpinned by principles such as access to justice, equity, responsible use, you know, then we can have these conversations. It's a very good point that you bring up. But it does get very dangerous when you start to say the advocate gets replaced by an avatar. What point do you say that the judge gets replaced by an avatar? And I think none of us want to head down that dystopian direction, right? Then we're in sci-fi territory, like the Matrix. Yeah, I'm always a positive or an optimist when it comes to technology. I do think that these challenges are not insurmountable. I think as a society and as humanity as large, we will be able to take this technology and utilize it best for everybody.
So let's get some benefit from your insight of having worked in different contexts. Are there any examples that we can borrow, best practices from other countries? And I know we've mentioned a couple at the start, but are there any specific examples that you can say would be a best practice that we can also adopt here in terms of making sure that these, you know, foundations don't get eroded and we use the tool for what it is and not more? Roy?
Great question. So is there best practices? And I had this same conversation with a client last week. And the argument or the conversation was, what defines a best practice now that AI is around? Because the norms that we've always believed as best practices is being challenged by a very objective generative model that suggests maybe there's an alternative way of thinking. And there's an alternative solution. Which is the power of the AI, because when we're using this kind of capability for the right thing, we can start to get deeper insights into better ways of working, giving us deeper insights into research, into advancements in technology itself. So a lot of positives. Now, when one starts to ask the question, what is a good practice, where is the advancement in practices to be a better practice? There is different industries outside, obviously, that we work with, for example, in the healthcare space, where the advancements, and I was just yesterday an announcement, or Monday actually, there was an announcement made, where there's a brand new model that's now being used to identify lung disease off x-rays, using the power of generative AI, language models. So not necessarily a large language model, I'll explain that. So we're seeing now opportunities where the practice initially was to take a perspective on a image, make a deduction, and take that forward. But now with the AI capability coming in, we're now seeing that as the new emerging practice. It still doesn't mean that you don't sign off on your diagnosis. It just gives you that extra insight. IBM practiced this with Watson quite a few years ago now. And the concept was really to go and do things like cancer detection, for example. So giving us different insights and quicker diagnosis, even coming up with different medicines, etc. During COVID, the rapid capability of coming out with different vaccinations, that was a lot of AI-driven methodologies and algorithms, although it may be not generative. So there's a lot of these good practices, and I think the pioneers in this at the moment has really been around healthcare. In the agriculture space, we've also seen this emerge. So we've been privileged enough to work in a few projects where we deal with rural farmers, where they don't have access to necessarily the infrastructure, laptops and technologies we have, but they're all on WhatsApp. So we are now able to take a diagnosis of their livestock or their crop, take a picture, do a generative analysis, come back with some recommendations, and then get support and assistance. So these are the kind of things where the right use case to provide the right output, we can start to move. Now, is that a good practice? Well, it's changing the game. And that's the sort of the philosophy, I guess, we're following at the moment. And it is one to kind of watch and see and be very vigilant about, because these things are fluid at the moment. And in the courtroom, and I suppose I want to say this, that you're never going to lose tradition. And we should not erode from those values. So to be able to kind of be the custodians of those traditions and using the technology to make sure that that gives us those right outputs within these parameters probably is the best practice, at least in the near future. So I think, again, it's one to watch. It's difficult to say what is right, wrong at the moment, but I believe that there will be a lot more of this emergence coming out in terms of this concept of responsible AI, ethical AI. There was an announcement just yesterday. African Union signed an AI declaration, of which South Africa is part of that constituency, to set the ground rules for these kind of topics. And those are the things that now will become best practice. So that's sort of what to watch for, in my opinion, at the moment. That then obviously can be tailored for yourselves as practitioners in this industry, of course.
I mean, talk about fast evolving. When I feel like we've managed to, find a corner in the conversation, it keeps blowing out again.
It keeps growing.
But one thing that does keep coming back is the notion of guidelines and making sure that things are maybe not managed, but at least adhering to certain directives that is agreed on. So, Judge, let me put this to you as as owner of the legal institution, if I may. Who do you think should be responsible to sort of? You mentioned was it the AU or the ECA you mentioned? AU. But who else do you think should be responsible for sort of getting this started, or is that even a job that anybody should have, really, because that's also putting too much power in some place? But what do you think?
Well, I think the legal profession in general should take responsibility for ensuring that those guidelines are developed, but the leadership in the judiciary should also keep a very close eye at it to make sure that we provide guidance in advance, or at least assist in ensuring that we don't fall into traps in terms of how the system is being used. So it's gonna need real focus and attention. And I may whisper to you that I know that there is some work going on in the judiciary to look at AI and its application to the court. Yes.
Okay. Okay, had to clarify. From the point of view of private institution, who do you think that should fall on? Do you think it should also fall to the leadership of the?
That's also a very good question. And to reiterate Roy's point, I think just looking at the context of AI applications globally, right? Roy was mentioning all of the different industries where we could learn from as legal practitioners how they applied the AI. We're in the privileged position again of having launched our AI platform in the United States 3 years ago. We launched it in the UK last year, and so we're seeing a lot of sort of trends emerge in the application of this technology in these common law jurisdictions. And I think we can draw comfort as legal practitioners in this country that it's something that's already been adapted in different countries and successfully adapted. I sort of contrast the reception to AI that I've had today with a lot of the advocates that I've spoken to here and around the panel as well before this, with the reception that I got at the LSSA AGM with the attorneys. Now, I'm not bashing attorneys, I'm an attorney myself, but it was a lot more hostile there, right? It was a lot more, is this going to replace our jobs, et cetera, a lot of the stuff that we mentioned. But I always liken AI to what happened when the calculator came out, right? You hear a lot of articles about teachers moaning that kids can't spell anymore and they can't do grammar because there's AI. But my argument is it's very similar to what the calculator did, right? It didn't stop people doing math. it enabled them to be able to do algebra because they didn't have to do arithmetic anymore. And I think as legal practitioners and just as lay people with regards to technology, we can take heart in the fact that if you are ready for it, it can enable you. It doesn't have to replace you. It doesn't have to disable you.
Just on that point. In fact, we were discussing just before we started how when case line was introduced in Gauteng, we were nervous as to what's going to be the implication to those staff members that have been doing those functions. I can say to you today, in fact, as we roll out in the labor code, we've now made requests that we need more people that are to be trained in certain areas. We've picked up that for our individuals who are non-lawyers, they will need some special attention, and therefore you do need skills of people who can attend to that. I don't think it necessarily would do away with jobs. It will necessarily require a redefinition of the roles of the staff members.
We did start late, so I just want to check in with Advocate Mavunda. Can we continue into the half hour that we lost, or do we need to stop at past? Are we good to continue until 7 or until 7? Is everybody okay with that? There are refreshments later on to compensate for the delay. Okay, let's get into something that we've repeatedly brought up, which is the Mavunda case. Now, Advocate Kagiso Magano was generous enough to send me a 30-page description of the case, which I have no problem admitting that I used the AI to help explain it to me. So I'm going to read you the summary that I got, and you'll tell me if I got it right for those of you who are familiar with the case. So, and for those of you who are not, this is the summary. So the Mavunda case involved an application for leave to appeal a previous judgment which became controversial due to the use of AI-generated legal citations. The legal practitioner submitted several case law references which were later discovered to be fictitious. The case serves as a cautionary tale about the ethical and practical challenges of integrating AI into the legal profession, highlighting the risks of relying on unverified AI-generated content in legal practice, and underscoring the importance of human oversight and verification. Now, we keep coming back to this because it's not going to replace humans, and we do need verification. But let me bring the advocates back on this. I mean, as far as the ease that you found with being able to work on cases faster and have more references accessible on hand, what would you say your biggest learning would be? What would your cautionary tale be about when it comes to looking at this case, if you were to avoid something like this to happen to you?
I think it boils down to what the ethical rules of the profession are. That at the end of the day, you still have an obligation to the court, and you still have an obligation to your client to make sure that whatever information that you put up on your papers, the information that you put before court, is the correct information, and understanding the implications of you putting incorrect information, what that might do to your career as well. So it all boils down to being responsible, that how you incorporate it in your practice, you do not allow it to take over the human element into it, that you must still exercise control and oversight as to what information you put before court. So that is how how I've been careful in incorporating it into my practice, to make sure that at the end of the day, the buck still stops with me. Mm-hmm. Is the information correct? Mm-hmm. And that boils down to one simply reminding themselves of their ethical obligations to both the client and the court.
Right. Sibatli, let me ask you something different, because David mentions acting responsibly, and we also talked about critical thinking earlier. I'm going to assume you were of a generation that had more access to internet while at school than some of us, right?
Yes.
Where do we harness this sense of responsibility when some of the earlier, the younger generations have found themselves thrown into it? Because I'll give you an example. A few days ago, I was reading an article, I think it was in the Daily Maverick, where they were talking about how South African universities are struggling with the amount of plagiarism that is happening. All the papers have perfect content, flawless grammar, but it's flat, and they know, but the tools that we had to detect plagiarism don't even work anymore. So, you've got a generation that is born into using this tool, and where do you start actually, is it possible even to harness the sense of responsibility, particularly also when we're talking about other nations that are talking about integrating AI education as young as 6 years old? Is it possible to actually have a sense of responsibility taught at this stage, or are we too far in it?
It definitely is. It's 100% possible. With all the advances they are in life, and I'm going to use a very basic example, a parent is still responsible for what they teach their child. And you as the child are also responsible to take the lessons that your parent gives you. That is how we continue to grow and know the right from wrong. And the same applies in our legal profession. What we are taught by the generations that came before us, what they have built for us to actually enjoy within the entire industry, it needs to be kept alive and respected. So as practitioners, we can't just step back and say, well, AI did it for me, why should I bother myself? That responsibility still stands with me because that's what I was taught. That's why we go through our mentorship. We learn the nuances of being an advocate from people who are advocates. So you can never walk away from that. It is part and parcel of this profession. So yes, there's still space for it, and it is a very important and key component in the grand discussion of AI and the legal profession.
And Claude, let me ask you, as again, oops, I don't know what happened. Okay. From the corporate side of things, how do you ensure that this concern is always addressed when you're developing your solutions?
Again, a very good question. I think, and Roy will help me if I'm wrong, because I'm not a technologist, but there's a big difference between an open loop LLM and a closed loop LLM. So a closed loop LLM is one that's trained on very specific data. Right, so in developing our AI model, we've trained it only on our database. So meaning, our own case law, our own legislation, the same content that legal practitioners have been using for decades. That's the only content that the AI is actually trained on. And also, very interestingly, it's not trained on what users input. So if one of our clients, an advocate or an attorney, drafts a pleading, it immediately erases that data. It doesn't build on it like a ChatGPT would. And so we take that very, very seriously, because for us that's really what's going to distinguish us from a ChatGPT, is that trust that the legal practitioner will have in us. No LLM, I'm told, can completely avoid hallucinations. However, because of the fact that our AI is only trained on our data, it's almost impossible for it to hallucinate a case, for instance, because of the fact that it can only use case law from existing sources in our database. Secondly, what also empowers practitioners, and the judge alluded to that as well, every single time we give content through our AI model to a legal practitioner, they're able to immediately click on hyperlinks that are referenced to the actual court cases. So they're able to do that research immediately, as opposed to having to go on another platform researching it. So to answer your question, it's something we take very, very seriously, yes.
Okay, and I'm guessing the idea is to have sort of inbuilt verification as we go along, so that we're not necessarily having to dip in and out and, again, create delays that we're working so hard to avoid. Very interesting. You raise a point about the training, like the data set. My knowledge is limited. I only go by the podcast that I hear and the stuff that I read, but there was an interesting point that I remember from one of the podcasts that talked about how most of the artificial intelligence tools that we have access to, at least the free ones that we have access to, are trained using data set that is mostly owned or generated in the West, specifically, Silicon Valley, California, etc. And it raises a lot of issues for something as simple as transcripts. You will speak and it will not understand you unless you sound like me. I'm very sorry about that. But it struggles to pick up different accents, and so it obviously immediately favors people who sound a certain way. But also just at the heart of it, the kind of data that's harvested, because simple things that when translated in vernacular that mean so much have no equivalent in English, for example. And so you find the data still limited. Now, are you telling me that we do enough data training in South Africa to sort of sustain how we manage to use this tool, or are we still very reliant on what comes out from the West? And I'll come back to you as well.
So again, a very good question. No, I don't think we do nearly enough data training. Most of the work that we're putting in from launching our AI model is actually training the legal practitioners on prompting. Because how you ask, and Roy was mentioning this earlier as well, how you ask the LLM to give you an answer is going to make a very big difference to the output that you get. And so training our users to be able to optimize what they get out of the AI is very important to us. But it's something that in the long term would be amazing to see in schools. But it's very difficult with technology. 10 years ago they said that we should start teaching kids to code. Now that's redundant because AI is going to code faster than humans. And so education is very, very difficult to adapt. But I do think, as technology companies, it's something we should be spending time on, right? And for us, it was, we've had these discussions and steercos within LexisNexis whilst we were developing the platform, where the technologists would just say, oh, this is amazing, and this is amazing, and this is amazing, and it's going to do this. But some of the people working in content, some of the people working in the commercial side, like me, who do come from the legal practice, would say to them, listen, guys, just chill. It's not going to work at all. Nobody knows how to use this, and you're speaking gibberish. And so there's definitely responsibility on us as well.
So I think the question really sort of stems for me around what is an hallucination, because that's the elephant in the room. So all these points, and Claude, spot on, I appreciate that, which is you need to understand how these models are constructed. And we've always had a philosophy when we built our platform to use the right model for the right execution and the right task. Many of us have been on ChatGPT. Probably by a show of hands, probably all of us. And if you haven't, I would doubt. But there's other models out, and there's new models coming out all the time. There's this concept of large language models. There's now a trend and a pattern to go to small-scale models, and by that we mean, like Claude has been explaining, more deterministic models based on determined data. The large language models typically are built off large data sets, yes, off the West predominantly, which is where this has emerged from. There's been some advances out in Asia with tools like DeepSeek that kind of threw the whole AI world on its head. And there will be this continuance of investment in models. And these models is what becomes the reference point for an AI to understand how to interpret your prompt, your request. And through fancy mathematics and deep analytics, and we're not going to get into all of that engineering, but it is able to predict a word. And that's what generative AI is in a very simplistic way. Is understanding a model, understanding your prompt, and being able to predict the next word. And it's a next word predictor, a very simplistic way. And where hallucinations start happening is when you start missing things like context. When you start missing purpose, you start leaving things too random. So the concept of a prompt really is trying to narrow down that repetitive deterministic outcome so that you can get the right information, the right predictive next word. And far too often, and this is really talks to the duty of competence, where we've got to inform ourselves, we've got to learn ourselves these new tools. Because if one doesn't understand how to work with those kind of capabilities or understand the nuances around, for example, how to prompt, how to give an AI context, how to give it boundaries, how to put guardrails, because that's the other aspect of why this thing can go on a tangent, then algorithms basically start predicting incorrectly. And that's when the next word becomes incorrect, the next word becomes incorrect, and it can kind of go on a divergent path. And that's what an hallucination typically is. So if one understands these fundamentals, and you start to understand that we've got to put context, we talk about another variable called temperature. So in other words, how deterministic should an answer be? In other words, kind of refining it to a point so that we understand that that word is quite predictive as the next one that should be interpreted, versus leaving it too open-ended for very creative. Then you can start to imagine. If you start leaving it too creative, this can go quite random. And if one understands these parameters, it can start to inform you on how to use the tools in a much more correct manner. And hallucination is always going to happen. There's always going to be an element of randomness because of the nature of the algorithms that define and the science and the maths behind how these things are defined. So when one starts to kind of unpack these, the questions to ask here is, what models are we working with?
Right.
Are we using the right models? Do we need to build our own model, like Claude was alluding to? Yeah. And I think that's the duty of candor again coming through, that transparency. We should be asking, what models are we working with? Is it a model that's based on certain bias? Is it a model that's quite defined for my purpose? And again, different models for different outcomes. To the question of, is there investments in South Africa? I hope that there will be more. At the moment, there's far too little. Yeah. There is sort of movement at the moment from the bigger players that are in the market to sort of invest in bringing this together. And I think that is a gap at the moment that we're sorely lacking, because we talked about inclusivity. We talked about the concept of multilingual. At the moment, everything's sort of foundationally based on English. Right. Which makes it quite difficult to take it back to dialect, back to local language. I mean, we got so many languages. So how do we kind of bring that inclusivity again? Yeah. And we need models for that, so that we can then obviously take advantage of that for our particular scenarios, of course. So again, I think, knowing these things, I would always implore everybody, and especially a little bit of hint today, make sure you understand the context. Do not leave things undefined. And then verify and reference back, because that's when you can catch these things. In terms of prompting, there's certain methodologies on how you should prompt. I'm not going to get into all of that. There's a variety of different tools and methods that you can use to enable you. And I would implore you guys to maybe just have that sort of understanding, so that when you are working with an AI and you see it diverging, you can bring it back and course correct it, because an AI can learn. It can learn. So it's important to again just take that into your cognizance.
Okay, Claude wants to add a quick point, and then I promise we will go to questions, because I do want to hear from you.
Roy made some amazing points there, and I just want to touch upon one with prompting and tie it back to the Mavunda case. Obviously, we don't really know what the prompting was in that case, because the candidate attorney and the director swear that these were real cases, still to my knowledge. But if you ask, for instance, a ChatGPT or an open source large learning model, show me case law that says that the death penalty is legal in South Africa, it's going to show you case law that the death penalty is legal in South Africa. It's not going to show you S versus Mahlangu, it's going to show you some authority that it cooked up, because that's what you've asked it. You haven't asked it whether the death penalty is legal in South Africa. You've asked it to generate case law, right? So that's important, and Roy touched upon.
And I think I just wanted to add further on that, because back to these large language models, what is the data trained on? And a lot of this data is opinion data. It's not factual data. It's blogs, it's news articles. And I implore you, next time you're on ChatGPT, for example, you bring up a case, prompt it up, and ask it for its references. And you'll find sometimes it doesn't have any. Or, most of the times it doesn't, by the way. Or now it will find some, and it's going to be to some random blog that was some guy's thought in the middle of the night.
Yeah.
Now you're interpreting that as fact.
Right. Which actually means, it's cliche, but be careful what you ask for.
Be careful what you ask for.
Okay, so...
Can I just say one comment?
Sure.
Arising from what has just been said, one judge in England said, AI is jolly useful. But don't use AI in a field where you're not familiar with.
Sure.
And I think it makes sense to me.
Sure.
If I'm given a case in an area that is unfamiliar, I would bring all the textbooks and put them next to me and work from there.
Right.
Or train your model on those textbooks.
Sound advice, sound advice. So let's open it up to the floor. I'd love to hear some of your questions. And yeah, let's get to it. I think we have roaming mics over there. Yes, gentleman over there.
Hi everyone. The traditionalist in me is hearing all of this, and I'm just, maybe it's a concern, but let me ask the question. The advocacy profession involves a lot of...
Would you mind holding your mic up so we can hear you better?
Oh, sorry. Our profession involves a lot of digging in. You dig in and... Oh, sorry. You have to dig in and then acquire the knowledge. You know how this authority relates to that one, and it's part of how you gain experience. I missed his name.
Roy?
Roy was speaking about his son who, from 50%, he's getting 75%, right? So how do we overcome the possibility that you could get somebody who produces nice sets of argument or knows some authorities, but this person hasn't gained experience? They just have a set of papers and it appears good before a judge, it's compliant, ticks the boxes, but you're not growing, even in terms of how you think, the critical thinking aspect.
Spot on. And there's a chain of thought that the more we use AI, the more we become complacent in its use. And that's really the sort of the foundation of the argument, because the more we allow it to think for us, the less we think. And I catch myself doing that sometimes. Is we create a lot of content, we create a lot of customer-related information, or we even build software using AI. And that, in a way, when we lose that critical thinking, when we stop being understanding, stop this understanding, we're allowing AI to start to dominate our thoughts. That's when experience, that's where the experience gap starts coming in. Right. And there is a risk for the younger generation at the moment, and I use my son as that example, where they're not going to get, you're not going to get any more experience because you're allowing an AI to fulfill that void, fill that gap. And one needs to be extremely careful of allowing that to happen. And that's going to be part of this responsible AI conversation that we're having, to bring out those values, bring out that vigilance, not allowing the AI to be now the dominant thinker, because it can easily become that. So yeah, it's a spot on question. I think the other part of it is we just need to be, not lose tradition, what defines us as humans and human beings. And that is where this is a very fine gray line that can be quickly traversed. But at the same time, it is an abyss that the younger generations, Gen Zs coming through, are AI literate. Everything's gratified through a mobile telephone at a fingertip. The newer generation has worked with these tools. They understand them. They understand how to work with them. They understand what to do with them. And I think it's also now to bridge that divide on how we can learn from the younger generation and bring in the experience of the older traditional cultural aspects and find a new convergence on that.
That certainly would be a divide worth bridging, and there's a lot of learning that can take in that space as well, that can take place in that space. Yes, I know you want to get to the snacks and go home, but this really would help sort of enrich what we're trying to get at.
As long as you don't ask the AI.
Okay, thank you very much. Me being that person who originates from the old school, where we used to sit around the table as counsel, as the attorney and the client, we're sitting with piles of books, and analyzing the case and trying to find principles, and at the same time trying to critically look at the principles, whether they still should apply in the environment that you are in. Now, I see with AI something that moves us away from that to a counsel that is going to sit in his chambers, or perhaps to a judge who's going to simply look at the AI, punch in a certain word, and then it brings up everything that he wants to see. Now, the worry that I have is, one, we know our responsibility as lawyers towards the development of the law. You move from the bad law and develop what then ultimately becomes the law. If then we've got an AI that is going to do everything for you, and that is going to research everything for you, you simply do a cut and paste and take it and put it there. It removes the element of the thinking, the actual discussion around the principles, and ultimately the development of new rights and law of the jurisprudence, in a sense. Now, do we really need this kind of development in our law? Do we really, really need it?
Thank you. I was hoping somebody would bring this up. Okay, go for it, Claude.
That's a very good point, and Emil's right. I think there are people with genuine concerns, like yours, that do need to be raised, and I think this is the right forum for that. So to answer your question around, the traditional, having the piles of textbooks, having to research, I think there's definitely a gap there for AI to replace the hours of research, get you the same knowledge, get you the same outcomes, but in say 10 minutes or in a half an hour as opposed to 4 hours. With regards to developing jurisprudence, I don't think an AI has any role in that, or should have any role in that. And I think that's up to us as a society to guard against. Because as you were saying, it does become very easy when both the counselor and the judge use AI to then have it be speaking to itself. And it's a fear that we should all be keeping at the forefront as we interact with these things daily. But definitely, I think it has a place in the legal profession. Obviously, LexisNexis, we're a traditional provider of legal content and assisting in legal research. And we definitely see our AI model as just a continuation of that. It's a tool for legal practitioners to use to develop jurisprudence, to advance the rule of law. So definitely, I think there is a space for it in the legal practice, but I think that there's some very real concerns we should all be thinking about and guarding against.
Can I see another? Yeah, go ahead.
Good evening, everybody. Firstly, thank you very much for a very informative session. I had a lot of questions, and the primary one was whether I'll still have a job in 2 years. I'm very happy that I will. And so as a joke, as the mic was going around, I decided to ask ChatGPT what to ask the panel as a question. And the first and probably the most interesting question on this list is, how do you see AI affecting the billable hour model in law firms and in our case, advocates?
Who would you like to answer that?
Any person, but I think that it would be more interesting if the judge tells us what is more ethical.
Judge, you're on the spot.
No, honestly, I don't have an answer for that.
All right.
Okay. So I think, great question. You would have maybe searched for this. There is a little clip that goes around when AI is speaking to an AI. It does get quite scary. So we don't know what they're saying, right? But how will billable hours change? And I think I want to use an analogy. We're working in the insurance space as well, and they do a lot of legal documents and policy crafting and quotes and so forth. And we've had an interesting challenge there, and just to the previous question further, is they can't scale the business. They've got too much to process. Are we going to get replaced? No. And all these questions that came up, and we show them the tools, and now they've got massive efficiency. They went from taking 4 to 8 hours to produce a document down to literally seconds, freeing up time to do other constructive things. So it's about using the right use case and the right tool, as I said earlier, for the right purpose. In terms of billable model, and that is a school of thought that I think we were debating at one stage, And a comment that was kind of passed, which is sort of resonated with me, is this going to change the way you bill? Of course, I think so. I think so. There's the traditionalists who are going to say no. And then there's going to be the younger generation that are going to throw this on its head and become more outcomes-based than per-hour basis. And they're going to be able to handle much more caseloads, much quicker, and bill more as a result. And this is a school of theory that, and I'll make an hypothesis that that's most likely going to happen in the near future. So there's already movement on that, and we've been working with one of the attorneys around a wills and testaments process, where it normally takes a consultation between 2 hours to up to 8 hours, sometimes longer, to craft a wills and testament. And we've got a big problem in the country with respect to that, right? And we now craft one. It's actually working next door. We actually craft one in literally 2 minutes. And it can now be pervasive across a large volume of people to kind of bring that inclusivity, because there's a lot of people that don't have a will, which are, don't always have the facility of a laptop and even privileged to get to an attorney to craft one. So and that's the opportunity. That's the little bit of that disruptive model that's going to come in. So where you're looking at billing per hour, you're going to have these disruptions coming in that's going to erode from the billing model for sure. We're seeing it.
It's a very good point there, Roy. And a good question by ChatGPT, because it is an elephant in the room.
By the way.
It's your amazing prompting, yes. To Roy's point, I mean, it's difficult. We've actually dealt with this in some of the other jurisdictions where we've launched Gen AI, right, in the legal fraternity, because to Roy's point, it's something that formerly you would bill 5 hours for would now take you a half an hour to do. And so it becomes an ethical conundrum, like, can I still bill for 5 hours? Can I bill for half an hour? Does that mean that now I have to do 6 times the amount of work? It's a very difficult question, and one that we're very sensitive to, because obviously the legal practitioners are still our clients. I do think eventually the billing model will probably in all event change, just because of the fact that a lot of the effort required and time required by a legal practitioner, now is distilled very quickly. What isn't replaced though is the knowledge, the training, the discernment of the legal practitioner. So what might happen is billable hours might be there, but you might just bill a lot higher for that knowledge, that expertise, that custodianship to the court. And it might just free you up to do other work, whether that be pro bono work, whether it might be spending time with your family, or spending more time in court. There's all sorts of outcomes that it might do. But what we've seen in some of the other jurisdictions where we have launched Gen AI capabilities, specifically in the legal profession, it hasn't actually upended the billable hours model at all. That still goes on. And what we found is a lot of our clients, and Roy mentioned this earlier as well, a lot of our clients are now able to bill more hours than there are a day. They previously were doing that anyway. But now they can realistically do it without lying. Yes, so I mean, it's a very interesting question, and one I think it's worth thinking about. But in the short term, what we've seen in other jurisdictions is it hasn't actually replaced the model.
I don't know if we were smiling at the higher billable hours part or the spending more time with family part, but I won't get into that. There's one more question over here. Ladies, I would love to also hear from you because I don't want the gents to dominate, but please go ahead.
Okay, look, I only recently learned how to switch on a computer, and I feel a natural deep contempt for any opponent who brings a laptop into court. But I do say this, I think it's human to think, and it's a human to fear. We'll never stop thinking. We'll fear that things like this will prevent us from thinking, but they'll just facilitate our thinking. That's the way it is. So I've no fear of AI once I learn how to switch it on.
Thank you for that.
Is the mic on? Okay, good evening, and thank you very much for the wonderful presentation. I know one speaker has already said that our jobs are secured, but are we really honest with ourselves? Or are we living in an illusion? I mean, for an example, the introduction of technology in Gauteng, we know Gauteng is leading with case lines, has taken away some of the common jobs that we know. I mean, I belong to a bar that for the last 3 years has never had a messenger. 15 years ago, you could never imagine more than 40 lawyers in one room without a messenger. We don't need a messenger because we file documents on case lines. We receive documents on case lines. We communicate with the court on case lines. And I think with this prompting and right questions to ask, the next jobs to go will be the legal researchers. I've never used them, but I guess those are the next to go. Because I imagine those people who are using legal researchers, they still double check what they've received from the researchers, which will be the same. If I prompt it to the ChatGTP or to whatever sources, I'll still double check it. I can imagine that is the next jobs to go. So to be so confident that we will still have the same lawyer in the next 15 years, don't you think that we are a little bit delusional? I cannot imagine, but I cannot imagine that a lawyer that is coming in the next 15 years will still be drafting and doing the research the same way that I'm doing, will still be needing the manpower that the same way that I'm doing. I guess there will be a stage where you just put in pleadings. I mean, for a judge, you put in pleadings and then say, give me the draft judgment.
So you actually bring up two very salient points. I mean, the first one is around, jobs disappearing, like the messengers, for instance. And I think that highlights a big problem that we have in technology at the moment and the rapid pace that it's developing. There's a cohort of, people that are well educated and able to adapt, that are keeping trend and evolving as the technology goes on. But then there's definitely an underclass being left behind. And I think that's something we need to deal with as a society. Do I think most of the people in this room have to worry about that specific divide? No. To your point around advocates and attorneys being the same in 10 years as they are now, I would argue that they're not the same as they were 10 years ago when I was in practice. And they aren't the same as they were 20 years ago. And I'm sure Advocate Mullins will also say they're definitely not the same as they were 40 years ago. And so we do adapt as professionals to the circumstances. And because of the fact that we do occupy a learned and a privileged position in society, we're able to do that. And so I do think it's incumbent on the individual to be sure that you are ready for that change, right? If you're still using physical pleadings versus people using case line, it definitely does slow you down in terms of the amount of work you can do, how quickly you can process, etc. So it's the same with Gen AI. I think it's just incumbent on the individual practitioners to stay sharp, stay trained up, and make sure that they evolve with the times. I mean, we've seen this recently in practice with the RAF, the changes to the RAF, how that process has changed. I was chatting to one of the advocates in the bar just now about the changes with regards to mediation and what that will mean to the profession. But I'm confident that the legal profession will adapt, and legal practitioners have a bright future.
Thank you, Edward. I think I share the bleak view that my colleague mentioned earlier with regards to us being replaced. We speak a lot about discernment, that us as the professionals don't just put into the computer and then it gives us a result without thinking. It's our job to discern and get into that information and decide whether it's correct or it's not. But do we not fear that the more we prompt AI, the more we give it information, the more it consumes information, it will eventually get to that point where it learns to discern that information? Because with more information it gets, the more it can then consider several points and come to a certain conclusion, which is what we are talking about now, that discernment. So is there no fear that as time goes on, the more it learns, the more that discernment may come? Thank you.
Judge, as someone who had referred to the human element of the practice, are you able to answer that in terms of, where does the human element go?
Well, I agree with my colleagues, but to say, yes, things will change, as things have been changing over time. I mentioned earlier on that in the courts, I initially also thought that all our staff members are going to lose their position. But what I find is that there are more challenges that are required in terms of training. So I think what is a challenge for the bar is to start looking into the future and say, what do we do to prepare for the future? Yes, indeed. I attended a conference in Boston the other year, and one of the people who were designing this system was telling me that at Los Angeles University, I think it was, that they were busy looking at AI to facilitate where you don't need a lawyer to prepare a claim for damages. You need somebody to speak into a computer and tell the computer what happened, what time did the accident occur, and this and this. And then the computer will tell you, these are the summons, you can go and serve the summons, and it will also estimate for you what your damages are. Now, that's theory, but as I listened to that, I realized, yes, this is a kind of a challenge that you are going to face. But for me, what it really means is, what is the bar doing to prepare for that? Because that eventuality for me moves away from where we said the human element is important. And if we lose control of the human element, then yes, I think people will be out of jobs. Practitioners are no longer going to be able to practice. So the challenge is upon you to say, what do we do to stop this thing taking over? I'm sure there are companies out there that are looking at making more money and that would want to get rid of lawyers and say, we'll do these things for you. So you can't take that one away. But if you sit back and say, well, AI is here, and you're not participating in terms of shaping its direction, I think that's where the challenge comes in.
I love that. Bring the human capital so that it doesn't outgrow, AI doesn't outgrow it. Do we have one more question? I hope the people are up for it, but yes, let's go for you.
Good evening, everyone. So for me, it's not necessarily a question, it's just a concern. Like when we take into account the POPI Act, I heard Roy mentioning when you are feeding the AI information, there's no security. You did mention that the AU has adapted some sort of framework or they're working on it, but I'm just raising it as a concern. As legal practitioners, we are, the POPI Act is being enforced now more than ever. Obviously, it came into effect recently, so I'm just posing it as a concern that when the AI is being developed, will there be maybe backup AI for protecting the information? For example, on court documents, you will have people's ID numbers, cell phone numbers, addresses, etc., etc. So if the public now accesses this, where does it leave the legal practitioner liability of now access to the public personal information? Thank you.
Spot on.
You want to take all the questions and then we go through them? Okay.
Yes.
Take notes.
Is it my turn? Yeah. Is it her turn? It's her turn. Okay. All right.
But mine is not so much of a question. Mine is what my colleague over there spoke about, which tied in with what Roy said about his 17-year-old using AI to get better grades in accounting, but not understanding the subject. And my colleague raising a very valid point that human beings, when they rely too much on AI, might produce better case and pleadings, but not be able to be a better advocate. And when you come to court, obviously you have to argue because remember we saw the clip about the person. So you have better papers, but you are not able to speak to your papers because the AI created the document for you, but it can speak on your behalf unless you use the avatar for it to answer. And when the judge engages that avatar, will it be able to respond? That's another question. But Judge, what I was interested in, wouldn't the solution then lie in the directives? Obviously, I'm not absolving the bars from having, you know, thinking about solutions of how this can, the AI can be used in their training and for us not to lose our ethics and be officers of the court. But if we have directives to the effect that if you've used AI, you have a duty to disclose. And that would be, I don't know, the regulator, the LPC. If you fail to disclose, it becomes misconduct. And when we have a scenario of Mavunda, and then there is an investigation, then that's misconduct, and then you are dealt with in terms of the act. Wouldn't that be the solution to some of the problems that my colleagues are speaking about?
Okay, that's interesting. We have another question there.
Okay, good evening, my colleagues, Senior Counsel, Protocol observed, Judge. Judges, of course, I should have started with the judges. DJP, thank you, Mons, for inviting me. Bumping into you, I was going to miss this session. Yes, I just wanted that example that you made, Judge. I'm concerned about what you said, and also I want Claude to come in. I'm talking about trial advocacy because that's where I'm passionate about. You talk about the jurisdiction that is introduced in the US and the UK, but my recollection is that with the NITA program that is run in the US, they allow that trial advocacy, the pupil or whether it's an attorney training, they must be there. The human nature must be there. And if we run the programs around the country, we allow practitioners to be present and bring judges to be there for them to appear in court. So I'm asking that example, Judge, that you mentioned about the damages claim. How are you going to tell the intelligence AI to say, these are the questions in cross-examination? Because you can't. So you cannot run a trial through artificial intelligence. You can't. Yeah, and I'm interested in the answer there. Thank you.
Good evening. I would actually just like to make a comment. We spoke about inclusivity. And in my experience, the use of artificial intelligence in court, like online court proceedings that are conducted on Teams, is contrary to inclusivity. Because traditionally, once pleadings are filed, they are public record. The public don't have access to whatever is going on in court. It is becoming such a problem that even counsel don't have access to court online until you are invited, either by your opponent's attorney or by your own attorney. And we all know about the problems with the state attorney. They just don't get emails. So you don't know what is going on on court online or on case lines. And then the general public don't have access to justice because traditionally a court case, unless there's a ruling that it should be conducted in camera, is supposed to be open to the public. And now you are inviting people to a certain channel and excluding whomever may have an interest in the matter that is being argued before the court, or even an amicus curiae who wants to join a matter that is of national or public interest, but they don't know about that until someone invites them to the pleadings or it gets leaked to the media. And then we know you can't trust what the media publishes on every count. So that's my comment, that it's actually contrary to inclusivity.
Thank you very much. Roy, mine is a quick one.
Getting all the questions.
Yes. Is AI a runaway train? And, or is it a weapon of mass destruction, wherein it sits in your office and it feeds, then who polices this animal called AI? Thank you.
I think those are all the questions we're taking, right? Let's start with the first one that we had from that side. And I guess, Roy, since you're getting the other questions, let me give this one to Claude. The question about how do we ensure compliance with POPIA and other protection laws that we have out there, how do we ensure that? And she had mentioned something about a backup AI, but not to get in that loop. What are we talking about here that can actually make this a reality instead of just something that keeps getting broken?
It's a big concern. I mean, and a very valid one to bring up. Of course, a lot of the data that you're feeding into public LLMs, that is, put out in the cloud, and they're using that to build their own algorithm. As companies, obviously, we all have to be compliant to POPIA. And again, David, Perez, the technologist, but from our side, making sure our data is super secure, making sure we use web providers that have, triple, 4, 5-factor authentication, white hat testing, all of these sorts of things, to make sure that the data is completely secure. But I don't think that's different from an AI perspective than it is to the rest of the technology industry, right? Your Gmail is also secured on AWS, on a very secure cloud system with, as I said, white hat testing and all of the steps that they have to take. As AI service providers, we also have to comply with POPIA. As I mentioned earlier, from our side, we don't train our large learning model on the input from our users. So it doesn't adapt according to what one advocate says versus what another one does. It immediately erases. But Roy wants to add something.
Yeah, so absolutely. So I think one of the tools we provide is called Workplace GPT, Business GPT, and kind of going to try to do two questions at the same time. So in terms of data security, that is something that we've been cognizant of for quite a while. So when we developed our platforms and our tools that was top of mind always, because we saw very early, and as new technologies have emerged, and we'll see these sort of trends and patterns coming out, we see this convergence to what I mentioned earlier, this private AI capability. And this notion of being able to protect your data and secure your data against security compliance standards, that's something that you need to be aware of. You need to be validating against. So some of the tools we provide are compliant against some of the industry standards that at least gives you some surety that we're looking after your data. The second aspect is around data sovereignty. Where does your data actually sit? So if one is looking at processing these kind of things off a cloud environment, one needs to ask the questions, where's the processing engine? Is it offshore? Is it in our boundaries? Is it sitting within our control? And that's where sort of these nuances of not knowing kind of brings that fear factor in. So knowing the fact that, and what we do is bring it to you. So solutions we host are in country, or in fact in your own data center, or can be even hosted in your environment. So within your control, your boundary, and within your parameters. So that gives you at least some comfort in being able to understand where your data is sitting. Because one needs to understand where is the data in motion, is it data at rest? There's all these aspects that are technically you need to now become literate of and become informed of. Because if you compromise that data, that could be tickets. Right? So we need to make sure that is always understood, and I implore you to ask those questions. The second question there is really, is this a runaway train? It could be. It could be. And that's part of the conversation of ethical AI, responsible AI, that these forums have to have. So what we do in some of the tools we provide is really around boundaries and setting the right, what we call AI firewalling. So under our platform, we give you capabilities where you can put the guardrails around the use of that data, what is and isn't allowed to be used. We can put sensitivity and classification so that in your data you understand that this is highly confidential or can be made to a public domain and therefore can be allowed to be used. And it's really providing, and we provide those tool sets so that you are able to make those policy decisions, because I cannot tell you if that document should be in the public domain or not. You would have to have that intuition and understanding that should be allowed or not allowed. So those policies in terms of both data and usage, when talking about Gen AI, is going to be fundamental for your understanding. And there's a distinct difference, by the way. So when we're talking about usage versus data, data is this document called pleadings, supposed to be confidential to me or to members and no one else, or could it be public? You can set that classification. But if I'm using the tool in an engine to go and do research, say, maybe we want to, in that usage context, we want to say this is not allowed to be used or can be used. So then again, now putting the right policies in place to allow you confidence in usage of the tool and of the data. Again, one last comment, what is in the public domain? And I suppose the question came up, what is best practice? Because that's actually what it's about now. COVID kind of changed the game, right? When proceedings still had to happen. And now that's become a norm. Is that now the best practice? And I think, again, it needs to be kind of brought back into context. And that's a fantastic question, because where does that data now sit? Where does it live? How does it become public information, if it is public information? Fantastic question. I'm not a practitioner in the case line tool, but I would suffice to say that these things are going to bound to start to happen and continue to happen. And hence it's that practical nature of setting up an AI charter that governs these controls that is going to give you sort of that insight. And that's really where we need leadership to bring that together and tackle that tough question.
Right. And the last two questions, I'll combine it to the leadership. There was a question about making sure that experiences revolve around, like for advocates, especially around getting hands-on experience as opposed to just being able to file claims and not having that, not having the human aspect of it erased, but also directives, punitive or otherwise. How do we ensure that people who do try to cheat their way out of it actually get called to order? So, Judge, how, and you mentioned proactivity. How do we include that as well?
Well, let me deal with the issue of the directive. In fact, some people don't like directives because they create their own problems. But let me say this, that as I said, I serve on the subcommittee of JAID, and long ago we developed rules for the high courts that took into account the issue of case management, electronic case management. I don't know where these rules are, but probably with the rules board. Now, yes, indeed, I agree with you. We need those directives. We need the rules. In fact, to make things easier, they need to be built into the rules. You'll see the directive for the labor court is coming into effect from Monday. And we tried to look at all these issues, and I'll come back to this question. How do you encompass what commonly has been used and is something that most people would be comfortable with, are used to, in as far as that is concerned? So I'll say I agree with you. We need to move. I would prefer, if we can. Fortunately, with us, the labor court, our rules board, we can convene it anytime within 2 years. So we are likely to get the directive back into the rules and address some of these problems. Coming to the question of public participation, inclusivity, yes and no, I agree with you to some extent, and I think the criticisms were raised some time back. Court online is not that fundamentally different from what the practice has been. I mean, now, before court online, you could go to the court and say to the clerk, I want this file. You'd give the file number, and they'll give you the file, right? The only difference now is for you to access, you need to register. And anybody can register. In terms of registration, it's lawyers, it's attorneys, it's advocates, it's individuals, it's organizations, right? It's unions. Once you are registered, you are entitled to approach the registrar and say, I want this particular case. That's the case number. She's obliged to let you have access into the case. So I don't see it as a major problem. Yes, there is the limitation as far as individuals are concerned, but all the courts are now required to set up help desks where individuals that are not legally represented can approach their help desk and say, I want this matter. In as far as your media is concerned, I don't think even in the current system, media just picks these things up. Somehow there's a source that will lead to them. But if they pick up there is a particular case that they need to have access to, in fact, in our directive, in the Labor Court rules, Rule 72, specifically mentions that media is entitled to register and media can access any case anytime. And you'll see that also in the directive. We've dealt with that and said, because we think it's a very important aspect in as far as access to public is concerned. So yes and no, I agree, court online to some extent may limit accessibility in that you don't just walk in there. But remember, walking in there means queues. Walking in there means, and those of you who've been in the labor court, it means you've got to get somebody to go and find a file that's lying somewhere, we think, at the corner there. And then they try and pull out that file, and then it's the wrong file, everything falls apart. So I'm not sure whether we still want to keep to that. I mean, I've seen people really, really frustrated, people traveling long distances, and then they come and say, we arrived here in the morning, we are now told we can't find our file. So yes, as I say, I think court online should actually, it's actually public. The public element is just limited by the technical requirement of registering. Okay. The question that Ma'am raised, no, I think we misunderstood each other. I'm not suggesting that AI should take away the training, the practical application of the law, no. I was just giving you an example of what I heard, but I used that to illustrate the risks. I think somebody spoke about the runaway train. It can be a runaway train. And I have no doubt in my mind from what I've seen with the technology that somebody is going to try and do something that will take away the human element. So we need to just be alert. I wasn't saying that it's a good thing to present it. In any case, for my view, it's going to be very hard and difficult to prepare a case through AI. If you start feeding into AI, the summons, the pleadings, and all those things, you're going to hit a snake when it has to be presented. Because any judge is going to pick up. I mean, let's agree. As we sit here, you don't walk into court and you find the comfort of a judge saying, oh, yes, good said. You get a lot of challenge, don't you? You do. So those who prepare there, and I guess judges will tell you, from my experience, I have even seen cases where a different counsel comes into the case late for whatever reasons and has to rely on somebody's heads. There are cases where you can see, you didn't prepare these heads. So that's my point.
Thank you so much. We've covered so much. I don't think any kind of summary will really do it justice, but in my humble and feeble attempt to try, we have definitely spoken about the pace of development of this technology, and it grows every day. You know, it poses challenges every day. But as much as we've tried to pin the onus on which body needs to, take the lead in sort of helping regulate that, I think a lot of the comments and the questions indicate that there's a big onus on us in terms of educating ourselves about how best to use this tool, being careful about what we put out there, and essentially making wise choices about that. We spoke about the importance of protecting or safeguarding data, and this is something that goes back again as the responsibilities of the vocation here that we're discussing. And And also, most interestingly, although we do have challenges, the infrastructural challenges, within South Africa, we are spearheading, and it is comforting to know that we have champions like the judge and like many of you in this room as well, who will make that a reality, and capable companies like the ones that Roy and Claude represent, who are working on it and ensuring that we also have a say in how the data that goes into it is trained. But at the heart of it all, maybe this is the romantic in me, but at the heart of it all, what I keep hearing is that without a better human, there is no better AI, right? And again, if I'm allowed to sort of make a reference to my simple profession, I'm yet to find a communication that was written without AI. I will look at it and I will know, not because I'm a genius, but because as a human being who's done this for a while, you can pick up, just like the judge can pick up, this wasn't all you, there's something missing here. So being better humans, like I said, it sounds cliche, but it really is at the heart of making good use of this tool. So thank you so much to our panelists for adding this, it's your interesting contributions and insights. We're definitely...
Pardon me if I might be speaking out of turn. I actually have one last question. I was actually quiet here, hoping that somebody might raise it. My question is directed at Claude with regards to everything that was spoken. Interesting discussion indeed, but as a room that is full of legal minds, I think as a layman in the IT space, there's just one nail in the coffin that you guys didn't knock in, and I'd love you guys to do it, especially Claude. And citing the Mavunda case, we live in a world where innovation will always be ahead of legislation. AI is there, and I say AI is a friend, and a very arrogant friend. Arrogance in the sense that I use it, but never once have I used it, prompted it, and it said, I don't know. It's always, I couldn't find. And an arrogant friend will always get into trouble, just like the Mavunda case. So the nail that you guys didn't nail hitting the coffin is, in your profession, the line that you walk is not gray, it's black or white. And this is the question. As AI is there, I've never heard anyone say that AI lies. So I'm actually asking Claude, today can we say that AI lies? Or are we still going to learn to tiptoe around AI, how to use it? But reining it in, I say the train is moving and you guys are falling behind. To still want to leave this room and go have supper, but without having said, yes, we need to align ourselves with these people that are prompting and building this AI. But as legal minds, you are falling behind. You are discussing as if it's okay to just be the end user, but you're not bringing yourself closer to these people that are building it to see the dangers of lying. I mean, there's one thing for AI to get things wrong, but citing the Mavunda case, it's not like it quoted a right case but got the date wrong. It just literally used a case that does not exist. So does AI lie?
Yeah, really, thanks. I mean, I think we probably didn't call it lying, but we did kind of refer to various ways that AI can end up not giving the truth, the phantom citations, and the way it's prompted. But let's take a quick yes or no, and then we can end off on that.
Yeah, I mean, you mentioned it correctly. I think we do tiptoe around the fact. We call it hallucinations, but realistically, it is lying. But the problem with using the word lie is it's a subjective term. Can a robot lie? Again, you asked if you ask the robot to give you case law supporting the fact that the death penalty is legal, and it gives you that case law, is it lying or is it just misunderstanding you? But it is a very good point that you bring up. Yes, AI does lie if we look at it simplistically. One of our challenges, and it's a good point you raised as well, is to make sure that we include our users, the legal practitioners, in the development of our tool. As I said, for us, the reason we haven't yet launched our AI model in South Africa is because when it happens, we want to make sure that our AI model is an arrogant friend in the sense that an advocate is an arrogant friend. He's somebody who knows what he's talking about, who's authoritative. So when you ask him a question, he can give you the right authorities, good answers, and actually address your need. instead of just making up answers. And so that's what our challenge is, and we're confident that we will deliver upon that in our model, but it is definitely a concern.
Thank you. I did take the liberty of just checking in quickly with Roy, and he agrees with that. So thank you for raising that point, Vile. So thank you, our panelists, for your contributions. This definitely has been insightful. Thank you to our audience, present and virtual, for your rich questions. This really has expanded our conversation on the intersection of AI, the practice of advocacy, and the tech world that we're busy navigating. Please do stay, enjoy the refreshments, have a chat with Roy and Claude's team. They're set up in the next room and they can share more about their solutions. From my part, thank you so much for this wonderful conversation and enjoy the rest of your evening. Thank you.